All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, April 4th. We have 3 House bills on the docket. We're going to start off with Delegate Pippy with House Bill 126. We'll then go to House Bill 639, and we'll end up with Delegate Stewart with House Bill 691. So with that, House Bill 126, Delegate Pippy, is anyone here to present that bill? Awesome. All right. Ooh. Isn't that your seatmate? Isn't that your district mate? All right. All right. We'll now move on to House Bill 639. Anyone here for 639? All right.
Yes, there is someone.
Do we have Valerie here? Okay. In opposition or in?
Who's presenting on behalf of
Okay. Actually, come on up, Valerie.
Okay. Good afternoon, Mr. Chair and members of the committee. For the record, my name is Valerie Skaversky on behalf of the Community Associations Institute, Maryland chapter in favor of House Bill 639. Under the current law, a restriction is unreasonable when it significantly decreases the amount of energy produced or significantly increases the cost of a solar collector system. What this bill does is turn a subjective standard into an objective standard. Right now, there is no current definition of what constitutes a significant increase or decrease. Why this bill is important is because it clarifies that subjective standard, where a restriction that reduces the efficiency by 10% or increases the cost by more than 5% is considered unreasonable. Without this objective standard of reasonableness, all parties involved are left to sort of argue amongst each other and potentially litigate the subjective definition of significantly. And so this bill is striving to avoid that situation. Additionally, this bill provides a clear process to challenge a restriction. It establishes that a homeowner may provide documentation from an independent design specialist to show that the restriction increases the cost by 5% or reduces the efficiency by 10%. As amended, to ensure that the independent design specialist has a reasonable degree of expertise, the specialist must be certified by the North American Board of Certified Energy Practitioners or has certified by affidavit to have previously designed at least 30 solar collector systems in the course of trade within the last 3 years. In closing, House Bill 639 will also codify current practice that a community association has the authority to install a solar collection system in the common areas as long as installation is not otherwise prohibited by law. With those reasons, we urge a favorable report on House Bill 639. Thank you for your time.
Excellent. Thank you very much for your testimony. It looks like we have a number of questions from the senators in the room. Every senator present, in fact. So we'll start. I'm kidding, Joe. All right. Go ahead.
As you could tell by my shaky voice, this is my first time testifying.
You did a fantastic job.
Oh,
You did
thank you very
an
much.
outstanding job. All right. Sorry.
Thank you.
Oh, really? All right. We actually have a question. We have a small question. Go ahead.
Not want to make you nervous. So, and if
all
you
right.
don't know the answer,
already
get back
am.
to me. So look, I don't blame you. I did that once at your age too, and I was nervous, so nervous. I just wanted to know on this, you know, it uses 5% and 10%. Does it, right? If there's a 5% increase in installation costs or a 10%, it reduces energy by 10%. Do you know where the 5 and 10% came from? And if not, get back to me, you know.
I will get back to you, but okay. I believe this is modeling Virginia law, so
Okay.
maybe coming from that, but I will 100% get back to you to make sure that I'm right on that.
Thank you.
So I'm just confused by the bill. I'm encountering it for the first time, so it's confusing. So if there's a deed, this covers deeds to property. So if there's a deed that includes an easement, giving someone the right to move across someone's property, and therefore you can't put solar panels there. because you would impede his use of the easement. And that would take more than 10% of the property. Would this prevent the owner from granting an easement for that purpose to somebody else? I'm sorry.
No,
I'm trying to make out exactly what this bill is intended to do and then what effects it has.
I am not sure how to answer that question, but I
That would be a
contacted
good-
bill
good
sponsor,
answer.
but I do have Grayson Wiggins here with me to answer questions if he wants to come
Let
up.
me ask Mr. Wiggins the same question.
JPR is
He's-
going
He's
to
more fair game than you are.
Thank you, Senator West. Yeah, on behalf of CAI Maryland as well. No, the intent is not to impact the easement, I don't believe. But I will follow up with you and get the specific answer to you. I'd be happy to do it.
Okay. Is CAI, I guess, in favor of this bill?
We are, yes, sir.
Gotcha. Okay, thank you.
All right, seeing no further questions. Thank you both very much.
Thank
Excellent
you.
job. Leave it to JPR to JPR. Okay. All right, I think that's the end of the testimony for House Bill 639, unless I've missed anyone. With that, that'll conclude the hearing for House Bill 639. We'll now move on to Delegate Stewart with House Bill 691. If we don't have a representative from Delegate Stewart's office, we'll move forward with, well, there are no other proponents. It's only an unfavorable panel, so we'll start. We do? Oh, here we go. Sorry, there it is, Zephyr Shaw. Here we go. All right. We'll do Calandra Young, Anike Gronk, Zephyr. I saw you stand up. Zephyr Shaw, if you want to come on up. And Jane Santoni.
I'll go ahead and get started here. Thank you, Chair Smith, Vice Chair Wallstreicher, members of the committee. My name is Zephyr Shaw. I'm Assistant Director of Advocacy for Access to Counsel and Evictions at Maryland Legal Aid. And I'll try to describe this bill the way that Delegate Stewart might. If you can imagine a substandard life or health threatening defect affecting multiple units in a building, imagine it metaphorically as a fire. Many units are on fire. And under the current rent escrow law, and in the view of the judiciary and opponents, you have their testimony. Every one of those tenants whose apartment's on fire should come down and individually file a rent escrow case. And this bill is a critique of that type of system. And the critique is this. In the course of all these individualized cases, some are going to succeed and some will fail, most often because timely payment wasn't made into an escrow account or a litigant couldn't come to court, so their case was dismissed. There may have been some type of intimidation or other type of settlement that caused one tenant not to be able to proceed with their, or choose not to proceed with their escrow case. And so maybe out of 25 units, 5 of these individualized cases end up with a resolution where the fire is put out, but the fire remains in those other units. And if you think about it as a fire, you realize quickly that because there's not been a systemic or holistic approach to this problem, this property, the problem is going to continue and it will continue to affect all the units because that's how systemic conditions affect a multifamily property. And so this bill is meant to address that by providing an opt-in procedure where a lead petitioner files, they escrow their rent, and that begins a process where tenants can join in as opt-in tenants and have the conditions which are substantially similar, related in the same building, addressed before a single judge in a single case. I can answer for more questions. I don't know if I could have more time, Senator Smith, but I can also allow my colleagues to testify.
Sure, we'll finish the panel, but I'm sure there'll be questions. If not, I have a few as well.
Well, thank
So
you.
I'll-
We urge your favorable report with sponsor amendments on this bill. Thank you.
Excellent. And just as a note, Delegate Stewart is the floor leader on a couple of bills on the House floor, so that's why he's unable to be here. But as soon as he's available, he'll come over.
Yeah, I'm talking to his chief of staff. I believe he's running over right now, so. Hello, apologies, I ran to the restroom. My name is Annika Dunbar-Gronke, and I'm an attorney with the Fair Housing and Community Development Project at the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee, as I have shared with this committee before, is one of the nation's leading racial justice organizations. We were formed in 1963 at the request of President Kennedy, and we use legal advocacy to achieve racial justice, fighting alongside people of color so that they have the voice, opportunity, and power to make the promises of our democracy real. Our Fair Housing and Community Development Project, where I work, exists to fight discrimination in housing through enforcement of the Fair Housing Act and to promote greater opportunity for low-income people and people of color, in part by advancing the promulgation and enforcement of administrative rules and laws that ensure equitable access to the crucial resource of safe, quality housing. Because of this work, we urge this committee to issue a favorable report on HB 691 with sponsor amendments only. One of the reasons for that is that the proposed bill, particularly as amended by the sponsor, is substantially similar to a highly successful summary proceeding process that already exists in New York City. In New York City, they have what's called a group HP process. And in that process, a tenant or a group of tenants can begin a proceeding to compel a property owner to correct housing violations in dwellings. I have brought with me an example of a group filing in one of those cases, should the committee like to see it. It's only 11 pages. All it does is name the jurisdiction, the venue, and the list of violations that the tenants all collectively allege that they're experiencing. There's additionally an attorney verification, wherein the attorneys representing the tenants verify that the allegations in the filing are based on client interviews and records. It's very standard. Given that the sponsor has proposed to amend this bill to require tenant groups to be represented by an attorney, the judiciary's concerns about unauthorized practice of law should be fully addressed. If there are any additional questions about this particular process, which is a helpful allegory, I think, in getting over some of the challenges to this bill, I'm happy to answer them. But at the end of the day, this bill will save lives because it will more effectively hold bad landlords accountable for subjecting tenants to conditions that threaten life, health, and safety. So I'll be available for any questions if anyone
Excellent,
has
thanks. We'll take questions at the end of the panel, but I do want to dive a little deeper into the unlicensed practice of law that you touched on, but we'll ask those questions as we finish up the panel.
Good afternoon. My name is Jane Santoni, and I am a consumer protection and tenants' rights lawyer. I am in the district court often on rent escrow and failure to pay rent cases, as well as in the circuit court on these issues. I'm here to address a couple issues. One is that we believe, and my experience shows, that if people can bond together, it will actually be a more efficient process for the court because certain things don't have to be litigated over and over again. My experience is that if one apartment or one residence has problems, chances are it's systemic. For example, the pipes are bad. There are a rodent population that goes throughout. You know, mice don't distinguish between apartment A and apartment B. So it is very common that the problems are systemic, and this is a way to deal with them systemically rather than have the court and the tenants have to deal with them individually. As far as the possibility of a class action being more efficient, as an attorney who practices class actions, I will guarantee you it is not. Class actions generally take years to resolve. Meanwhile, we have clients who are in untenable situations. As far as attorneys' fees exploding, I will say that because the Consumer Protection Act in Maryland has an attorney's fee feature, and there are about 8 lawyers in the state that practice consumer protection. So I don't see this as a boon for greedy lawyers or an explosion of litigation. It is a way to address a problem. And I'd just like to close to talk about a client that I helped the other day, young woman, 2 babies, a 4-year-old and a 2-year-old, bed bugs throughout her apartment. She had no idea how to file a rent escrow. The ability to have counsel present, as well as to bind together with the other people who had similar problems, would have been a huge help. Her number is legion. Thank you.
Chairman Smith and Judiciary Committee members, my name is Trent Leon Learman, and I'm the Maryland Organizing Director for CASA. 99% of CASA members are low-income tenants in Maryland. For so many of them, they are forced to suffer because of a huge lack of urgency on behalf of some landlords. We first go to management and they say they're working on it. 1 week later, they're still working on it. Norma lived in her apartment with her sons for 4 months before management finally moved her and her neighbors to new units because of rampant water leakage. Esmeralda was without heat with her family, as many of her neighbors were, for 26 days in this January, in the heart of winter. Jeanette climbed 7 flights of stairs for weeks despite being disabled because of a non-working elevator that affected her whole building. In all of these situations, tenants were doing their part by paying the rent while landlords were not doing theirs. In counties where DPI, the Department of Permitting, Inspections and Enforcement exists, they don't have capacity to always enforce the codes. We called 33 complaints into DPI in 1 weekend in early April last year. And in numerous cases, DPI wasn't able to even go to the property until June. We have found that when management doesn't respond and DPI doesn't exist or doesn't respond, judges are the only ones that can truly prevent safety and health hazards. And so often tenants don't file a rent escrow case despite being in danger. They don't have time to miss days of work, or they can't find a lawyer that will help them. Sometimes they are scared of retaliation. I have never seen more than 1 escrow case filed at a time, except when we talked to a group and we did 10 different individual filings for the same issue. It was tedious and difficult for all the tenants. The Tenant Safety Act would improve the health and safety of so many tenants, both by acting as a deterrent to landlords not maintaining their property and by solving a common problem for so many with 1 single rent escrow case. Less people will be without heat and electricity for weeks. My last sentence. Less people will be in danger of mold, broken ceilings, and infestations because of leaks that affect multiple units. We ask that you support HB 691 for the health and safety of so many low-income Marylanders. Thank you.
Excellent. Thank you very much. I see the sponsor has arrived. I know you were busy leading a bill on the floor, so we thank you for making an appearance here.
No,
I know it's a tough schedule to keep. So Delegate Stewart, welcome. Floor is yours.
Thank you. Thank you guys very much for having this hearing. Mr. Chair, Mr. Vice Chair, esteemed members of the Judicial Proceedings Committee, for the record, I'm Delegate Vaughn Stewart, and as y'all have already heard, this is House Bill 691. I just want to first reiterate, first of all, my apologies for being late. Also, my sincere thank you for having another bill on this topic that wasn't sponsor only, even though I know you already heard the Senate bill. So I'm really sorry that I'm late because I don't want to be repetitive, but I'm going to go in 2 parts here. I'm going to briefly summarize what the bill does with some new sponsor amendments that we submitted over to this committee, I believe yesterday, and that we've submitted to the judiciary, and I also submitted today to the landlord community. I want to talk through what the bill does as amended, and then I want to walk through as quickly as I can, because I want to be respectful of y'all's time, why we did those amendments and why I think they address the remaining concerns. But what I first want to do is just say I'm deeply grateful for the collaboration that we've received from the landlord community as well as from the judiciary. They've had a lot of really helpful input in this process. I'm hopeful the amendments that I'm going to lay out today will mitigate their concerns entirely. But they may get up later and say that it doesn't. And if that's the case, to me, that's just the start or just the continuation of what has been a weeks-long conversation. I don't think it's the end of it. We've got 6 more days until Sonny dies. So I just want to reiterate that I'm very, very serious about this bill, but I'm even more serious about working with all the folks who have concerns about it to make sure we get to a consensus product that can help regular folks, but they can also do so in a pragmatic way that moves us forward and that makes sense for the entire judicial system. So first of all, what problem are we trying to solve here? As y'all already heard, both in the previous hearing and so far in this one, Marylanders have the right to a safe and habitable home. That's existing current law, but it's exceedingly difficult for tenants, especially our most vulnerable neighbors, to exercise that right, because oftentimes they've got to skip work to go to these court hearings. They've got to hire an attorney if they want to have a realistic chance of winning, and it's tough. And so what's the result? I mean, the result is that basically, this morning and every morning in Maryland, children wake up in dangerous conditions. They live in uninhabitable conditions. Our neighbors, little boys wake up coughing because they have mold running along their ceilings. Little girls wake up and, get ready for school, brush their teeth, and they have rodents crawling at their feet in their bedroom. And so that's what happens. And so this bill is, I think, a small and pragmatic step to trying to fix that problem. As amended, the legislation would facilitate initial joinder by tenants living in the same apartment complex who are all dealing with serious threats to their health and safety. So we're not talking about aesthetic things. We're not talking about their, cracks in the paint, cracks in the molding. We're talking about imminent, serious problems. And we are going to allow, for the first time under the rent escrow statute, under this bill, multiple tenants, 2 or more, to file a suit together initially, rather than just one. So that's the core of what the bill does, as you all know. But all tenants would still be expected to pay into rent escrow. And if they fail to pay into escrow, or they fail to pay their landlords, they're going to be subject to a failure to pay rent eviction. We're not trying to help bad faith tenants who want to try to exploit this process to stay in their units when they're not paying. That's not the goal of the bill. We wanted to make sure we prevented bad actors from being able to exploit any sort of loopholes in the bill. So here's how the process would basically work. A tenant identifies a big problem in their unit. They notify their landlord of this problem. They wait a reasonable amount of time for the landlord to fix this very serious and dangerous problem. Once this reasonable time elapses that the landlord hasn't done anything to fix it, then that tenant could band together with other tenants in their building and file this initial rent escrow action together. The other tenants would have to be experiencing the same problem. So if I've got rodents in my unit and my neighbor a couple units down just has mold, that's not the same problem. They wouldn't be able to join the same group action as me. And then I would have to make a number of prima facie showings to move forward. I'd have to, for example, show that it is a serious defect. The landlord could raise defenses. For example, the landlord could raise the defense that I caused the problem, and I would have to rebut that defense. The landlord could raise a defense that I didn't provide access to the unit for the landlord to inspect the problem, and I would have to rebut that. If I was the plaintiff, would have to rebut that. And so only after that prima facie case is dealt with, only after all those defenses are rebutted, and only after a showing that all these problems are substantially similar, only then would the court open rent escrow bank accounts that then we'd all have to pay into. So, well, again, we've got to put our money where our mouth is. We got to put our money on the line because we're trying to get a safe and habitable home. So I'm now just going to walk through the remaining concerns in the judiciary based on the letter that's in your packet and what we've done in this latest set of amendments to try to resolve those concerns. First, they were concerned that the bill might require the lead petitioner in the case to practice law in a way that would be, as we lawyers call, UPL, the unauthorized practice of law. To address this concern, one of the new amendments requires that the group of tenants be represented by a Maryland licensed attorney. So we think that that does away with that problem. I'm hopeful that it does. Secondly, the judiciary was concerned about the bill's relatively unclear process for substituting a lead petitioner. I think this was a very good faith concern from them. The new amendments provide that if the lead petitioner is dismissed or withdraws for whatever reason, then another tenant can request to become the lead petitioner as long as a bare majority of the other tenants in the case agree. But it takes the court's process out of that. The judiciary was concerned that they were going to have to be wading in and deciding who the new lead petitioner would be. So the new amendments puts that onus on the group of tenants and not on the judges. So I'm hoping that that conversation or that concern will also be mitigated. Third, the judiciary articulated several concerns to how the bill initially was drafted with respect to joinder. So the original bill, as y'all may remember when you had the Senate hearing, after this whole process happened, the tenants were allowed to basically notify other tenants in the building who may be experiencing similar problems, and then had a joinder process for them to sort of join the lawsuit after the fact. The landlords had concerns about this issue as well. And so I went to the tenant advocates who were standing here and we had a tough conversation. And honestly, I think they're still a little bit mad at me, but I decided to remove the joinder and notice provisions from the bill entirely. So there now is no opportunity to notify. There's no opt-in after the fact joinder. If this group of tenants doesn't come in initially, they can't come in. And so I think that knocks out a lot of the concerns from the judiciary in the letter. And I think it also knocks out a lot of the concerns from the landlords. I'm hopeful, at least. We'll hear from them. Maybe I'm wrong, but I'm hopeful. Fourth, and finally, the judiciary expressed concern with the district court possessing the necessary resources to litigate especially large or complex group actions I do think that the joinder provisions partly address that concern, but just in case they don't go far enough, we've also added a new amendment that allows the district court to transfer group actions involving 20 or more units to the circuit court, where they have more resources to litigate these more complex matters. Now, if 20 units is not the right number, I'm not wedded to that or to any of the amendments. I'm happy to come down to 5 or 10 or whatever makes sense, but we went with 20. We'll hear from them momentarily if that works. So just briefly on the landlord concerns, and then I'll shut up. A lot of their concerns, I think, are technical and therefore hopefully fixable. I do share their concern about tenants trying to make use of this process, as I mentioned, without paying rent to anyone, but I do think the amendments address that issue as well. There is one remaining substantive issue that the landlords may bring up. Now, we met them 90% on the landlord's concerns, MMHA's concerns over on the House side. There is one substantive issue that we did not address in the bill, and I'll leave it up to the committee, and I'll explain why I didn't take it. They're concerned about the fact that these groups of tenants can sue across apartment complexes instead of just in the same building. They think that's not fair because you could have multiple city blocks of buildings and you can't possibly have a similarly situated situation if you got one tenant in apartment A or building A, and then you got another tenant in apartment building F down the street, that they can't be substantially similar. And obviously the bill requires their issues to be substantially similar, so if they won't, they'd be kicked out anyway, but they're concerned that that's just too big of a footprint. And I hear that concern. And ultimately it would be up to the committee if you guys want to make that adjustment and make it about buildings only. But my thought was, even if you're in the same broader apartment complex with multiple buildings, when it comes to like heat or electricity not working, there could actually still be substantially similar issues that could span an entire apartment complex owned by the same landlord. So that's why we kept it in. But I think that's one remaining substantive issue that's still in. If y'all want to go in a different way, I'm not going to be that upset about that. In conclusion, I just want to reiterate that I really appreciate everyone's good faith concern about this bill. I really appreciate you guys being willing to hear me drone on for 15 minutes about it again. We got 6 more days. I'm committed to making something work on this. I hope the folks behind me, I know they are as well, and I'm hopefully we can get something done. But I really appreciate y'all's thoughtfulness, and I urge a favorable report.
Excellent. Thank you very much, Doug. So that'll complete the panel for the proponents, and we'll have questions from the committee now. So Senator West and then Senator Sidnor.
Thank you, Delegate Stewart, for bringing this bill. I will say it's a complicated bill, especially with all these amendments that we're being hit with today.
I agree.
We had a not quite as complicated a bill between landlords and tenants toward the beginning of the session, and we worked on it for like 5 or 6 weeks before we had a kumbaya moment. And then we passed the bill. It was Senate Bill 100. Senator James and I worked on it, and I think Senator McKay did too. And I'm concerned we don't have time enough to do that kind of work on this bill at this stage. But let me ask you just a couple of questions.
Sure.
So on page 4, you've according to this, you struck out the word money before damages. So bring an action for damages, not money damages. What kind of damages are not money damages?
Well, equitable damages, or, in terms of a remedy, it would be equitable or specific performance, or attorney's fees would potentially be a damage. The reason that we did that is because the judiciary, very early on in the process, they flagged this issue of money damage as being problematic. So we took that. That was actually one of our first amendments that we did several weeks ago, is we took that out. Now, I think the landlords are still concerned. That part, I think, that they're specifically talking about relates to the other part of the bill that I didn't even mention, which is codifies the implied warranty of habitability. Our goal with that was just to codify existing law. So I think that damages line is just existing practice. It's already been codified in Baltimore City. So I don't think that would change anything, but we wanted to strike money damages because the idea from the judiciary is that would essentially bring in kind of an entire new cause of action into the game.
Okay, well, that was going to be my next question. I found that the provision on page 4 about bring an action for damages. But then when I went through the rest of the bill, I couldn't find anything else about damages.
Right.
So what the bill seems to do in its current form,
Yep.
and I haven't seen the amendments that you've just offered
Right.
now, is it allows an individual tenant to bring an action against the landlord for damages, but it doesn't allow other tenants to join in the action. Am I right on that?
That's correct. So it codifies existing practices on damages as it relates to the implied warranty of habitability, and that's just a solo individual person. The provisions that I laid out around group actions are a distinct other part of the bill. And those would actually not yield damages in any kind. It's
Okay.
only for specific performance, meaning please fix the problems.
Okay, my original impression was that this bill in some way was going to conflate an action for rent escrow with an action for damages. But
Right.
in its current posture, it doesn't appear to do that.
Correct. And that was one of the judiciary's initial concerns as well. And we worked with them that was actually an easy one. We were able to resolve that on the House side pretty quickly.
Okay, and my one other question today, sure if we end up doing a work group, I'll have a lot more, but for
Sure.
right now, on page 6, section 8, it says, following the entry of judgment in the petitioner's action, no tenant joined in a petition under this subsection may initiate a separate action to seek the same remedy. So is what this bill is trying to do is to designate the lead tenant as someone who's going to control the fate of anybody else who joins in the action. And if the lead tenant does a poor job and screws up and the case collapses, as I read this, none of the other tenants who were joined in the petition can file an action on their own to deal with the problems that they're facing.
That's largely correct. So this mirrors kind of an opt-in collective action or mass action that's common under the Fair Labor Standards Act in that context. And when you do opt into a group action like this, you are one thing you're doing is that you're surrendering your own rights. You're stopped from going through with that process, not withdrawing, seeing it to the finish line, losing, and then trying to seek your own action on the same issue.
Well,
Now, I do think, to your point about the lead petitioner messing up, because we're now under these amendments requiring this entire group to be represented by an attorney, the role for the lead petitioner is basically just to sit there and look pretty next to the attorney. There's no other real role. So there's no real way for a lead petitioner to mess it up. Now, if the attorney messes it up, then yeah, everybody is that's too bad for everybody, right? But that's just how the legal system works. If you get a bad attorney, then you could be doomed.
Sure, but is there any requirement in here that another tenant who is persuaded to join in this action gets some sort of a notification in advance that about what the ramifications are of joining in the action, that the other tenant who has rat infestation
Yes.
may lose the other tenant's right to complain about the rat infestation if he joins this action and the action fails?
Yes, the tenant would be notified about their rights and responsibilities, remedies, and lack thereof if they chose to join.
Okay, and that notice is provided in the bill?
Yes.
Okay, great, thanks.
Thank you very much. I was looking on page 2 and I was just curious. I noticed the term, and I believe it was in the old law, line 23, 24, and 29 farm tenancies. I'm curious, are we talking about sharecropping?
I think that was an exemption to make clear that the bill does not apply to farm tenancies, where nobody's going to be sharecropping, or
But that's what it means, right? Sharecropping?
the farm tenancies.
Uh-huh.
No, I think farm tenancies relates to, it's an old like 19th century sort of concept related to sort of like working on a farm and also living there, but it's not specific to sharecropping. But either way, it's not in the bill.
That's what I thought, sharecropping.
We're not doing anything with farm
No,
tenancies.
I know, that's, again, I know it's from the.
That would be a
old
whole nother
language.
work
Curious
group.
With farm. Okay.
Yeah.
Thank you.
Senator Washington, I believe, is next.
Thank you. After hearing the amendments, what protections are in this bill again? For
Sure.
tenants? How can tenants benefit from this?
Yeah, no, it's a good question. I mean, I feel like we have moved pretty far in the direction of trying to be reasonable to all sides. And so it's a fair question. Essentially, what the bill would do that right now can't be done nearly as easily is for a group of 2 or more tenants to join together initially and file a group action to force repairs to dangerous defects in their unit. Right now, perversely, and I think kind of crazily, we force tenants that have the exact same problem that may be living right next to each other to file, if there are 8 of them, to file 8 different individual actions. And then if they get a remedy, let's say 4 of them get a remedy, even though maybe all 4, the problems were real elsewhere, or maybe you have a 9th person who didn't file anything. The remedy is only specific to those units. So even if you have a mold, and of course, I know you know this, endemic to a 32-person building, if 8 people sue and prevail, there only needs to be mold remediation in those 8 units, which I think is not only a situation that is kind of crazy from the perspective of tenant justice, but is maybe even crazier from the standpoint of judicial administration. So just as I said in the House side on this, just as we allow witnesses, in fact, we sometimes, at least on the House side, I don't know about you guys, encourage witnesses to say me too, if they have the exact same thing to say as someone else that has already testified. This process would still, even in its amended form, allow multiple other tenants with the same problem that's also serious in the same building or the same complex to essentially just say me too, and maybe not have to go miss multiple days of work to get their problems fixed.
Got it. So, I mean, so what were I'm sorry, I came in a little late, but there's some protections that we had initially in the bill that we're taking out. Are those, everything is still set where it needs to be?
Yeah, no, I mean, the protections are still in. I mean, I think what we took out were some important. I think the biggest concession, and I think you may have been here for this part, but the biggest concession that we took out is that there's no longer a notice and opt-in provision in the bill. So previously, we essentially would have allowed a situation where, you file an action and by yourself, and then maybe you get to post a notice in the building that's like, hey, I've got this action going. If anybody else has rats, shoot me an email, you can hop in.
Yeah.
That was in the initial bill. And I think that would have been in some respects good, but I'm also sensitive to the judiciary's concerns that from an administrative standpoint, it would have been a headache. If you had people coming in at multiple times over the course of several weeks, it would have been a little bit of a maze for the judiciary to navigate. And so that's why we took that out. But I still think that the bill before you is extremely strong and I think would make a tangible difference in a lot of people's lives.
Got it. And we're talking about inhabitability.
Correct. We are.
So we're talking about the most extreme
We are.
cases. There was a witness testimony during the crossfire of this bill that stated that tenants, sometimes act for these types of situations just for new lights in the community. Would that fall under this at all?
No, absolutely not. This has to be a defect that's imminent and serious and dangerous to someone's health or safety. And that's the first thing they have to prove. So when you go to court, even before the judge opens the bank account, you've got to prove that this is something that imminently threatens your life.
Correct.
And I certainly don't think that random lights would do that.
Correct. And so I wanted to just ask Mr. Leon Learman if he can answer a question for me, because he's from my district in Greenbelt. And so I was hoping if you could these are serious concerns, these serious situations, these are inhabitability. I know you've seen it. Can you just give us 1 or 2 examples of what you've seen out there that caused this such a big issue and why this is so important to people and why we just can't wait for something like this to wait for a work group to happen, but maybe we can get something done this year to help these vulnerable residents and tenants. Is that right?
No, yeah, I really appreciate that. No, this winter, we had one complex without heat, the whole complex, right, for 26 days, and they couldn't get it resolved, right? And another complex, we had a mass water leakage, right? So it flooded the whole garden style apartment from 3rd floor to the basement, right? And so we're talking at all 12 units, right? They were flooded and they couldn't get moved to new apartments for 4 months. We're talking about no electricity, and another occasion that happened. So yes, these are all scenarios that are real. This is happening right now. We see tenants suffering for months right now because they can't get the help they need.
And sometimes these tenants are low-income residents. These are folks that English is their first language, or they don't speak English at all. And having someone to be the convener, essentially, of this group could help them. Is that right?
100%, right? So, as Delegate Stewart was saying, right? Instead of all 12 in that unit in that building that got flooded, having to miss days of work, maybe a couple of them could, other than all 12 filing separate rent escrow petitions, they'd file one. They wouldn't be as scared to file it because they'd all be on the same petition. There's just multiple reasons why this makes a huge impact, and we think simplifies it for the judiciary.
Yeah, and this is just so concerning because we're talking about low-income residents, people that don't speak English, people who this is their place of habitability. This is their place they have to live because they have to raise their kids in. And we're asking, I know that you've been through this of working with the local departments of DPI and property standards and getting violations done. that process takes months upon months for something to occur before the landlord even wants to fix something or agree to fix some of these conditions. Is that right? You went through county government.
100%. I mean, in places where the DPI exists, you know, I mentioned it, we filed 33 cases in one weekend. And so in many of those cases, DPI didn't come out for 2 months. They're overwhelmed. You know, they don't have, in various counties, they don't have enough staff or budget. And we found that only the judge, oftentimes, unfortunately, the bad acting landlords will listen to the judge. That's it.
And this is just another tool, just one additional tool to help residents, to help where they can fix the issues that are happening in their properties so that they can live with their kids in a habitable place where it's, we're talking about livable, something just livable, you know? And so for us to wait another year, for us to wait for a work group, these folks need tools now, is what I'm hearing from you.
100%. Yeah. This is what they've been doing for too long, paying their rent and not getting those safe conditions met.
Thank you.
Thank you.
Thank you, Mr. Chairman, and I don't mean to follow up too much on Senator Washington, but unfortunately, I wasn't here yet when we had the Senate crossfile of this bill. Thank you, Delegate Stewart, for what was very detailed and thorough description of the amendments and the work you've done. And obviously, you've put in a tremendous amount of work to try and find something at least close to a consensus product. So I want to thank you. Before you got here, the advocate on the far left, I think she's with the Lawyers Committee for Civil Rights. She mentioned that this is similar process is working very well in New York City. So I was wondering if either she or you could expand on that a little bit for us.
I'll let Annika do it.
Yes, of course. So as I mentioned, thank you so much for the question, Senator Kelly. There's a process in New York, a summary process, and I mentioned that because it's very important here. There's been some confusion, an understandable confusion, because there are multiple people that would be involved in these cases. That this looks kind of like a class action, but very flatly it is not. And that's exactly why I brought this this example of a filing in a group HP process in New York. What happens there is that a number of tenants, like I said, come together and they are all together at the time of the filing, similar to what Delegate Stewart has proposed in the amended version of this bill, and they can all go before a judge at the same time, alleging the deficiencies in their living situations that that they allege that they all share, and you know, they name the parties, but they really focus on the violations, and that's significantly different than a class action, because a class action is meant to there are lead members that are meant to represent a large class. That's not the case here. Everyone will still be involved. Everyone will still be a part of this filing and will be represented by that same attorney. The difference is just that it will be easier to pull everybody together. It will move more quickly because, again, a summary proceeding means that it's all going to happen quickly, just as Ms. Santoni was discussing during her testimony. But I also want to name that in New York City, because there are these really, really large buildings that exist, and we've seen over the last probably 10 years, a few different examples of buildings that where tenants haven't been able to access attorney and haven't been able to use this process. People have died, right? And we've seen that in Maryland as well. And like it's very common that there are really awful conditions, and that's the fault of like a bad landlord. The purpose of this bill is that it will ensure that tenants can hold a bad landlord accountable. It's not all landlords, it's just the ones that aren't doing their job, right? And I think that that's something that you know, the folks in New York City are really careful to do. They don't go after you know, landlords where an attorney can't say, oh yes, I've talked to tenants about these conditions, and I've seen the evidence that shows that, you know, people are living in uninhabitable conditions where the landlord is actually operating illegally because they have a duty to provide habitable conditions. So I hope that answers your question.
Thank you. And some of my questions are probably are going to be less than clear because I don't have the amendments and I don't have, I really unfortunately, I don't have the judiciary's comments.
Mhm.
So just a couple of questions. One, I've heard people mentioning particular incidences that seem to have really brought about the desire to get something done. Where are those happening? What counties are those happening in?
I think it'd be fair to say it's across the state. I mean, I think that what Mr. Leon Learman has described, I think, is largely in the counties surrounding the Washington, D.C. metropolitan area. But I can tell you from working on this bill for a couple of years, speaking to the kinds of moms and dads who are living in these horrific conditions, nightmarish conditions. I mean, I've spoken to them where they're describing the conditions of their units through tears. And it's happening all across the state. I think probably if we mapped it out, there'd be a higher per capita incident, maybe in the more denser parts of the state where you have these larger apartment complexes that are a little bit more dated. But I don't necessarily think that I would certainly not go so far as to say that this is a problem that's only narrowly targeted in a couple of jurisdictions.
So I represent Harford County, so
Yeah.
I'd be very interested in
Yeah.
information about Harford County because I had not heard sort of at least the dramatic cases that you've brought up here. So I would be.
Yeah, we can try to find
interested.
that for you. Absolutely.
And then of course, there's been the mention that this is modeled after or inspired by or both. I don't know, this New York
Yeah.
statute.
HP actions. Yeah, that's what they're called.
Is it a statute?
It is a statute.
So when was that statute enacted? A while ago, was it?
The 2000s. Yeah, I think it was the early 2000s, but we'll find that for you in a
And
second.
is it any, big country, lots of big cities, lots of landlord tenants? Is it anywhere else in the country other than in New York City?
To my knowledge, no. I mean, probably in other countries, yes. I don't think we've necessarily taken a deep dive internationally, but in the United States, to my knowledge, New York City is the only place that has it.
So it'd be very helpful to me because I like to read and research on my own. So I
Sure.
would like to actually get very much the site for this.
Yep.
And so I can get a copy
For
of
sure,
it.
we can definitely get
And
that for
then
you
I
as
can
well.
do some research on my own on how
Yep.
it's been working. And then just on attorney's fees, is there, you can already get attorney's fees in Maryland under certain circumstances.
Correct.
So why did you feel, so in a way, you're just telling the court it may award attorney's fees.
Mhm.
And I think somebody can demand attorney's fees and there
Yeah.
are mechanisms for doing it.
Yeah.
So I'm not sure why we have that language.
I'm
So,
happy
and I
to
don't
walk you
think
through
it's
it.
necessary, to be honest with you.
Sure, I'm happy to walk you through that. When this bill initially came in, it was a shall. We said that when a tenant prevailed, they shall get attorney's fees. The point here was to essentially incentivize attorneys to take these cases. And a lot of these sort of situations where you have rent escrow cases, the tenants are pro se. And as we've all talked about in the context of access to counsel and eviction proceedings in the last couple of years, when you're pro se as a tenant, you pretty much are not going to win. You're going to win maybe less than 1% of cases. So we added that shall attorney's fees language because we just wanted to induce some attorneys to actually take on these cases. The judiciary and the landlords both came back and said that sort of mandate on us is not appropriate. In cases that maybe it's a close call, for example, we don't think it's fair to give only the tenants attorney's fees and not the landlords, for example. So one of the concessions we made over the last few weeks is we actually changed that from a shall into a may. And our expectation is that only in the most egregious cases will judges use that option to award attorney's fees to tenants where perhaps the conditions were so bad or there are so many of them or the evidence was so compelling that it makes sense to do that. But I get your point. And I would also add that, currently under existing Maryland rules, if someone's action is in bad faith. So for example, if a tenant joins the action because, for example, and I think this was actually Senator McKay's concern, if I remember correctly, but my memory's not that good. So tell me if I'm wrong. If a tenant tried to essentially Me Too onto this action because they were just trying to get out of a failure to pay rent eviction, well, number one, that just wouldn't work because if they're not paying in a rent escrow and they're not paying their landlord, they're going to get evicted under the provisions of the bill. But to your point, in addition, that kind of bad faith action would actually yield a possible attorney's fee switch the other way.
I would just tell you, I disfavor language mandating awards of attorney. I feel like
Yeah.
the courts take each case on an individual basis. I don't like tying judges' hands. There are mechanisms for when you can, recover attorney's fees. And certainly if you're going to give it to one side, the option, literally in statute, I don't see why you couldn't on the other side as well, especially if this were in any way abused. Hopefully it never is. But there's merits on both sides of it. So I have a lot more questions too, but I know other people have questions. So if I can just get a little bit of information, I could start doing. some
Yeah, we could
research.
totally
We-
provide that
We can
for
do it
you.
after the hearing, then. We can do that. Thank you. Thank you.
Thank you, Senator.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill. So how many bad actors are we talking about?
In terms of landlords or tenants?
Not
Landlords.
landlords.
It's a small minority. I'm not going to try to say that it's anything resembling a plurality or a majority. I think the vast majority of landlords, and I said this on the House floor, just like the vast majority of every profession, does a good job. They act in good faith. In this case, they provide a service, a product, but a service to the folks that they're supposed to. What this bill is about is essentially just a truism. And the truism is, if you pay, you should get a service. If you're a paying tenant, and you pay your rent every month, you're entitled. You should be entitled to getting something back for that money. But unfortunately, there is a small, I can't name an absolute number or even a percentage for you, but I would say easily less than 5% of landlords, maybe even less than 2% of landlords in the state fall into this narrow confines. And so I think if you're a good faith landlord that's providing housing to people in the state and you're trying to do your best, maybe you're a small landlord, maybe you're one of these big guys, the vast majority of them have nothing to fear from this bill at all. This bill, the whole design of it is supposed to be narrowly focused on the very, very small fraction of landlords who allow serious problems to subsist for weeks and months and sometimes years without ever lifting a finger, despite the fact that they're in violation of Maryland law. And we're just trying to make it a little bit easier, just slightly easier for our most vulnerable neighbors to exercise their rights to a safe home.
With all the amendments, and maybe you already addressed this, so I do apologize for asking again. It was brought up that through the judiciary's opposition of this unauthorized practice of law.
Right.
Those amendments address that?
I believe so. We'll hear from them. I haven't heard back from them yet on the amendments. We'll hear from them in a second if it does, but they did have this concern about if the lead petitioner has to represent the interests of this group in any way. Their concern was, are they practicing law without a license? And I think that's fair. We wanted to address that. And so what the amendment says is that this group action, you have to actually be represented by a real lawyer.
Okay.
So I think necessarily it takes that issue off the table.
So my third question, thank you, sir, has to do with a hypothetical situation.
I love it.
So in the property code, rent escrow code, section 8-211, talks about different very specific requirements on how it applies to an escrow account.
Yep.
And it's talking about a reasonable time.
Right.
So my hypothetical is, you'll like this. I used to be in the textile, well, I am a dry cleaner, but I used to be in the fire, mold, and smoke textile rehabilitation business.
Mm-hmm.
So you have a apartment fire. Didn't burn everybody out, but there was lots of smoke damage that has gone out through the hole. Not everybody has been affected that they can't live there.
Mm-hmm.
Okay. However, smoke is different to each and every different family. One may be allergic to it. One, it's going to be fine.
Mm-hmm.
How does these people go find where they're going to be living? But it's deemed that it's allowed to be there.
Mm-hmm.
How does the reasonable time go into actually that whole process
Mm-hmm.
of going through the insurance company, having people still live there?
Right.
What I can see, I have been through textile record. Can't even think what the name of it is, but anyhow, it takes a serious long time to get everything right.
Yep.
How do we not see that 5 or 6 tenants who are, hey, they want their place back? I'm not saying that they may have had some smoke damage or whatever. How does the requirements for the rent escrow affect this particular hypothetical? Because reasonable time to one person may not be a reasonable time to another.
Yep.
And I just can see this becoming a rat's nest. I don't know how you undo that.
Yeah, I appreciate the question. So the reasonable time language in the bill, and just for everyone's benefit, what we're talking about here is you give notice to a landlord that there's a problem. So in your case, there's been smoke damage. Obviously, in that kind of situation, the landlord would need notice. They know, but the tenant would have to provide actual notice to the landlord. And then a reasonable amount of time would have to elapse before the plaintiff, the tenant, could file a rent escrow action. We're actually not changing that provision of the law in any way. Reasonable time is existing Maryland law. And I know that the landlords have brought up this concern, and I think maybe they want like a more specific number. And I'm not really opposed if we want to change current law on this issue. That's not really, to me, one of the big remaining issues. But I think actually having that flexibility for the judiciary to be able to say, in this case, the amount of time was reasonable. For example, if it's something you could fix really quickly, like maybe you get some sticky traps out and you try to remediate a huge rodent infestation, maybe you better get on that within a few days. Whereas in a scenario like you're talking about, that could easily take several months to resolve. I think that the best course of action is the status quo, which is to allow judges to be able to decide for themselves what is a reasonable amount of time and what is not. And for better or for worse, as y'all know, on this committee, the reasonableness standard is something that we ask judges to parse all the time. And I think I ultimately trust their wisdom on that sort of case. So short answer is that the way that would play out under this bill is no different than it would play out under existing law, with one exception. You could have 5 people sue under the same claim under this bill. Under the status quo, they'd have to file 5 separate actions. But otherwise, the reasonable amount of time elapsing and all that would remain the exact same.
And my only concern is those 5 different people, or those 5 different people could have 5 different what reasonable time is and how it all affects. And therefore, the landlord in this case is beholden to the insurance company to figure out how they're going to be able to break everyone back to becoming whole. And I'm not saying I'm not in favor of the bill or not in favor of the bill. I'm just saying,
yeah,
I think there are issues that arise. And it goes back to my original question of how many bad actors are we actually talking about?
Yeah. And
I'm concerned, not that the tenant or a bunch of tenants would intentionally use this, but I'm telling you, I just, there are situations that are beyond control of both the landlord and the tenant to understand that everyone has the same expectation of that reason. But thank you.
Yeah, and I would just add, and I appreciate that question, and I think that it's a legitimate issue. I would just say that the way the bill would work is that each tenant, despite them being in a group, each tenant would separately have to prove that prima facie case. They would separately have to prove that, prove that they gave notice, that they allowed someone to look at their unit, that they allowed a reasonable time to elapse, that it is a serious defect, not just like maybe they have an allergy or something, but like they can no longer live there. They would each have to make their own separate showing as part of this group represented by an attorney. And so I hope that that kind of process would resolve some of these concerns, maybe not bad faith concerns, but sort of misuses of the law.
And the word I couldn't remember is restoration. Thank you.
Thanks.
Senator West.
I mean, just briefly to follow up on Senator McKay's concern, when there's a class action case, there can't be class actions in district court. They're only in the circuit court.
Correct.
And these cases all are in district court.
Correct.
But when there's a class action case, there has to be determination by the court that each member of the class is similarly situated. And therefore, they're all in the same boat together, as it were. Senator McKay raises questions about how in one of these cases, someone may not be similarly situated. Are there provisions in your bill for a judge to make a determination of whether a person ought to be together in the class as opposed to excluded?
Yes. So there's basically language that's similar to Rule 23 in the class action. Of course, the big difference here in class actions is most class actions are opt-out classes, where you have a similarly situated population and maybe they receive notice in some way that they can opt out, but a large group of people are automatically in the class and then they can opt out. Here, we're talking about an opt-in class where you have to affirmatively add yourself. But if you'll remember from civil procedure, Senator West, two of
It's
the
been a
four.
couple of years ago.
Two of the four requirements in Rule 23 for class actions are commonality and typicality.
Right.
And we have essentially tried to mirror both of those requirements in the similarly situated language that's in the bill.
Okay, maybe offline. I know we stay in the same hotel. You can point out to me in the bill.
Yeah, I will.
Where that language is.
I can text you, but if
Thanks.
not, I'll see you in the hotel.
That'd be
Yeah,
great,
thanks.
sure.
Yeah.
Thanks. No, I see Delegate Pippi's here, so I'm not gonna ask all the questions I want to ask. We'll talk offline, but just, some of the things you were describing in terms of each tenant having to kind of make their case and prove their own. It sounds a lot like consolidation and the burden that's on you for consolidation. So I'd like to understand, the difference between consolidation, obviously for the district court, vice circuit court.
Yep.
For class actions.
Yep.
And then another thing is, you opt into this class, but then you mentioned that you're kind of stuck. And then I know you now have to be represented by an attorney, which is the amendments that are forthcoming that we are now in receipt of. But, the tenant's interests can still diverge under this scenario. And so I'd like to explore how you handle that situation when, things start to diverge and you're represented by the same counsel and you're now stuck in this class.
Just very briefly on the consolidation issue, we can't talk
Yeah.
offline about the pitfalls of a consolidation and why that's so narrowly used and the problem there and why this solves the problem. We can talk about that offline, but just very briefly on the issue of being stuck and having your interest diverge, you can still withdraw. So you're not actually stuck. If someone joins and they're like, oh, this attorney's not good, or, oh, these people are actually not as similarly situated as I thought, you can back out.
But what about this? So can you then you can relitigate the same matter under
Yes,
different
you
counsel?
can. If the process has not gone to its fruition and there has not been a judgment, then you can back out and you can litigate a separate claim.
And then just when you're talking about the burdens of proof and the kind of the hurdles, it just sounds a lot like consolidation. So just,
Yeah, we can talk through that. Yeah, I mean, I think that like the more we amend the bill, obviously, like the more it starts looking like that. But I
Yeah.
think there are very, very clear differences and benefits to this sort of process, both in terms of judicial administration and in terms of just how weighty it is on the backs of the tenants.
and then just, understood.
Yeah.
All right, we'll have more. We'll talk
Yeah,
more.
thank you all very much.
Additional questions from the committee? All right, thank you all very much. Thank you. All right, so now that concludes the testimony for the proponents of the bill. We'll now move on to the opponents and we'll hear from Chief Judge Morrissey. We got Judge Green. We'll have, is Bill Costelli here? Grayson Wiggins is here. Ryan Washington. And then Aaron Greenfield. Is Aaron here? Chief Judge, floor is yours. Welcome.
Good afternoon, Chair, Vice Chair, and members of the committee. For the record, my name is John Morrissey, and I'm Chief Judge of the District Court of Maryland. The Maryland judiciary remains opposed to House Bill 691, even after all of the multiple attempts at amending it. The bill is just unworkable, but I did want to say I've presided over hundreds, if not thousands, of rent escrow cases. Judge Green has probably presided over more than I. And I've seen horrible things. I've seen bad landlords. I've also seen tenants that have caused a lot of the problems that necessitated the rent escrows. And so there always needs to be proof. And that's the fundamental problem with this bill. I just want to make clear that all of the remedies are already provided for in statute. The warrant of habitability is codified in Baltimore City, and it's in common law. It's a recognized cause of action in the state of Maryland. You can already file a rent escrow based on mold under the current existing statutory construct. And you can, as you mentioned, Chair, you can consolidate cases. So if you file 10 cases or more and they're related, you can request the court to consolidate these so they can all be tried at one time. In fact, we kind of like that when you do that, if we can, for efficiency's purposes. But that's different than a class action. And what the sponsor and all the people have testified is, and I think actually I even heard in the New York bill, all the people have to show up at one point to show the court that they are commonly situated. And this bill doesn't provide for any of that. Someone at trial has to prove that each of these have the same problem. So at one point, I believe Delegate Stewart said that the lead plaintiff is just there as figure dressing. The lawyer will do everything, but you all that are attorneys know you have to call a witness to present evidence of something that happened in there. And this bill lacks that. That's the main problem with it. And I'm really not sure that you can amend around it. And my kudos off to Delegate Stewart. He has been trying to work with us, but sometimes, you know, if you've ever edited a paragraph, sometimes you just can't make it work. It just doesn't work because it's not fully baked, I guess is the best way I'd say it. Currently as it exists right now, it would potentially cause the unauthorized practice of law, because you're not just simply filing a document with the court. You'd have to, the lead tenant would have to investigate the condition of the other apartments, gather evidence, identify that this really is a substantial and serious threat. And mold could be a good example. Mold could be terrible in one apartment and minor in another apartment. And so it has to be a serious and substantial threat to the life and safety. And someone has to group all that together and draft and then file and then be ready to present evidence to the court of these conditions. And if they're not an attorney, that really would, I believe, in my opinion, be conduct that would likely be considered the unauthorized practice of law. And then, as we've kind of mentioned, people have mentioned around here, the district court doesn't have jurisdiction over class actions. If you look at the Maryland rule, it's 231. All the 2 rules are circuit court rules. That's where the class actions are tried in this court. So the kind of hybrid, well, I understand the theory behind it, and I think this can be accomplished by consolidation rather than this trying to blend or force a class action into the district court is just unworkable. We're not set up for that. We're a fast-paced court. I think in the entire 18 years I've been a judge that I've only had, I can count on my hand, a trial that has gone more than 4 hours in my court. It just doesn't happen. And that's kind of, the district court is designed to do one thing. The circuit courts are the courts of general equity, and that's what they're designed to do. So given the gaps in the language, the silence on important issues that affect the operation of the courts, and really the potential for the court users to engage in unauthorized practice. One more thing. I know in the amendment that I saw, they say, that in order to effectuate yourself of this class action provision, you'd have to have an attorney to do that. But that kind of limits unrepresented people from they can't have the same access then to the court system as people that are represented. And that's not something generally that we favor. So for all those reasons, I'd ask this committee to have a unfavorable report.
Thank you, Chief Judge, and we'll hear from Judge Green. Just to clarify, no, please, Judge. I know that we called you all up together, but the judiciary is separate and apart from, the other interest representatives, to make sure that that's clear for the record, but not that you all had questions, but just want to make sure it's there. All right.
Thank you,
Judge, please.
Chairman Smith, Vice Chair Wallstreicher, and members of the committee. My name is Jim Green. I'm an associate judge in the District Court for Baltimore City. And so I do very much appreciate Delegate Stewart's work on this and work with the Maryland judiciary and our concerns. But as the chief has just indicated, we still stand opposed to this bill. We're calling it very much a collective and not a class, but it really looks like a class, acts like a class, and for all essential purposes is a class. As was discussed, Senator West and the chief, the class rules really live in the circuit court and is governed by 231 as to class actions themselves. And their prerequisites as to determining the class. And certainly a number of the prerequisites in class determination have been expressed by the proponents of the bill. And that's very laudable. And we're certainly working very, very hard in handling thousands, hundreds of these cases and thousands of these cases and really trying to work to remedy. This is the statute 8-11 is remedial. And this is what's very, very important to all of this. It is a remedial piece of legislation such that it can be actioned by a defense to a failure to pay rent. It can also be filed as an affirmative action. And we see both of those. And we consolidate these matters very rapidly in the district court because the intent is to have the remedies addressed. It's to have the landlords address the remedies within a 30-day period. The statute governs that. And there's actually a rebuttable presumption that currently lives in law as to the redress in 30 days. The organizing that would take place to get all of the like matters together and the tenants, that's built-in delay. And that's not what we're striving for. We're striving for just the opposite. We're striving for that person who is not paying rent because they haven't had this issue addressed. And they're asking the court to consider this as a defense. It is a defense. As was indicated in the bill, it codifies the warrant of habitability that is already part of the public local law in Baltimore City. And we handle that. And we do handle the exchange, Senator West, as to the damages and the escrow, but we're really having to deal with the escrow primarily first. And then sometimes we'll schedule or specially schedule the damages aspect of the warrant of habitability. And that's where there's this interlie and crossover on the unauthorized practice of law. And I recognize that the amendments that Delegate Stewart has shared with the judiciary deal with this limited group or what proposes to be a limited group. But the limited group in and of itself could cause even removal to the circuit court. The removal to the circuit court potentially, and again, I'm not docketing cases in the circuit court, but certainly recognizing the impact on their dockets, its scheduling and the transfer of these matters is also of great import. The court is charged in this legislation with dealing with the substitution of the lead tenant. So if the lead tenant's matters are remedied, and it's just as Senator McKay was saying a moment ago, if the lead tenant is, and that issue is dealt with, and that issue has been dealt with, or the lead tenant fails to fund, the bill deals with that. There is a substitution as voted by the majority, but requiring potentially even a court hearing. That would be collateral to the escrow proceedings that need our attention so that they can be remediated quickly. It is what we see in all of our courts. So across the state, not just in the larger jurisdictions, we see, as the chief said, a number of issues that must be addressed, by the landlords, because that is what is contracted for. And certainly a number of matters that need to be likewise addressed by the tenants. And we balance that. That's the court's role. It's the balancing of that. And where this legislation focuses is the court, it takes the court's eye off the ball. It takes the court away from acting quickly, which is what we need to do in these types of matters. If there is a consolidated damages claim, certainly, perhaps there could be a class that certifies to the circuit court, and that's more involved, and that sends that message that the proponents discussed a little bit earlier. That's not my role. That's certainly something that we charge to you and greatly happily do so. But the issues surrounding the complexities of escrow, we lose sight of the fact that escrow is remedial. Escrow is to be a quick determination to remedy this quickly. And we try to do so in short order. Sometimes these cases do go on for several months, but that is the extent of it. It should not go on beyond that because of the guidance that has already been dictated in 8211 by this. So we do ask for an unfavorable report. Very pleased to take any questions that the committee has in this area. Thank you, Mr. Chair.
All right. Thank you, Judge. We'll take questions at the end of the panel. Thanks. So. You just play musical chairs there.
Yeah. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in opposition to House Bill 691. I do also want to thank the sponsor for really trying to work with us, but there are still a number of practical issues that I will highlight. You have my written testimony. Let me talk specifically about some of the provisions in the bill that are problematic that seemingly shouldn't be. Actual notice, this collective action or whatever we're going to call it, the tenant must provide, the lead petitioner must provide the landlord actual notice. Well, what is actual notice? It's not really defined in the bill. Is actual notice to a porter? Is it to leasing staff? What is actual notice? I would argue that actual notice should be clearly in writing, and it should be with proper service on the resident agent, if this is the kind of action we're talking about. We've talked a lot about damages and attorney's fees. As Senator West said, money damages have been stricken by the bill. And we're still curious about the kind of damages this would really cover. Further, as you know, tenants can be awarded attorney's fees under this bill, which is a significant expansion, as I read it, of the rent escrow statute. And attorney's fees, as was mentioned, should be mutual in the event that residents bring a frivolous claim. There is some confusion about rent escrow accounts. I heard the sponsors say that everyone pays into the account. Such an action should only occur if every single resident pays into each separate individual escrow account. The bill is unclear. As I read it, relief can be based upon payment simply by the lead petitioner. This opens up the possibility, which you've heard before in the cross-filed version, of residents just glomming onto the action and withholding rent and not having to pay into escrow. So that's a problem. The sponsor raised, and I'll be very quick on this one, the multiple buildings issue, which we still have a problem with under this bill. The collective action could go through multiple city blocks, and which is hugely problematic. And I would just say, I know one of the arguments by the proponents is efficiency purposes. I would argue that this does just the opposite. Each of those residents should be subject to cross-examination for due process reasons. For those reasons and others, we respectfully request an unfavorable report.
Good afternoon. Sorry. Good afternoon, members of the committee. Thank you very much for having me. My name is Ryan Washington. I'm with the Apartment Office Building Association. We still remain opposed to HB 691 for the following reasons. It circumvents the existing rent escrow process, authorizes a resident to bring damages against a housing provider based on allegations on material defect, allows a resident to provide ambiguous notice to any employee of a management company in any manner, including verbally. And lastly, what I'd like to just highlight, it adds mold to the rent escrow statute without including any corresponding standard for courts to use as a guideline or identifying which types of molds actually present serious health threats. As you know, many of housing providers across the state of Maryland, specifically in Prince George's and Montgomery County, take mold seriously. However, a lot of times there is no ability to assess the responsibility of mold on the tenant, whether that occur in the bathroom when it deals with moisture and just maintaining that level of moisture and control. AOBA believes that there needs to be some sort of guidance or standard for the courts to require proper detailed guidance on regulation to guide their decision-making in such instances. This may present legal challenges for many of our members, as residents will be able to seek damages for mold that may not be life-threatening to the health or safety of the individuals of the community. And with that, I'll withdraw my time. Thank you. And I'll stay for any questions.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. I'll be brief. I do also want to thank Delegate Stewart for speaking with us. I think the more I read through this bill, the more I think of a comment that is a consistent refrain in this committee, which is that concepts are wonderful, but what matters are the words on the paper. And as Judge Morrissey pointed out, there are significant procedural and process issues in this bill, specifically due process issues where you may only have one tenant coming to court when 20 are listed as petitioners. We've seen other issues with the bill as Senator James pointed out, the attorney fee issue. One of the proponents mentioned that you would not see a large increase in attorney fees. We have a case involving one attorney and one tenant, separate matter, where an attorney requested $587,000 in attorney fees. I'm gonna say that again, $587,000 in attorney fees. You, Mr. Chair, mentioned the issue of tenants getting stuck in an action. Based on the most recent amendments I've seen, it appears that Delegate Stewart now has created a situation where if the lead petitioner leaves or is dismissed or withdraws, the remaining tenants will, I guess, vote, and a simple majority will select the lead petitioner. But in cases where there are issues that have already been decided by a court, the remaining tenants, I guess, will be stuck with that case, even though they may not have voted for the lead petitioner. Candidly, I've never seen a provision like that before. You've also got a provision in here that says that nothing in the section can be construed to restrict other tenants from joining the action. So if I'm a tenant and I bring an action and my neighbor down the hall has caused the issue that I'm bringing an action for, that neighbor can just jump on my action now. And does the landlord have the ability to use that as a defense? These are open questions. There are a significant number of more open questions in this bill beyond just the due process and procedural concerns. Thank you.
Thank you all, gentlemen. And I, understood all your concerns. So, and I think they're all substantial, valid, and I see that the bill needs a lot of work. But let's assume this bill is not the right vehicle for all the reasons. And but we hear that there is this 2%, 3%, 5% of landlords that are really, really bad actors. And And that I don't know how this is happening, but there are tenants who are without heat and water, for 25 days in the winter. And, you've heard some of these stories. So I would just like to hear from any of you, maybe the judges in particular, about, do you see this frequently? And do you feel like the district court is able to remedy the most egregious cases? These stories are terrible. I don't think this bill's a solution, but it also seems that the way the system works now, something's quite amiss in a small percentage of extremely egregious cases.
Sure, I'd be happy to.
Mr. Wiggins, if you could give the chief sorry, thanks.
Sorry. You sit over on the house side, you stand in the Senate side. Kind of used to sitting, but that's okay. Thank you for the question, Senator James. I think the best way to explain that is that the rent escrow as it currently exists in the district court is a very efficient process. Someone can file either affirmatively, so they start the action with the rent escrow, they pay their money to the court clerk, and then that case is brought before us, or they failure to pay rent comes and they come into court and they say, Your Honor, I've got terrible mold in my house, or there's a fire that's damaged the house. And I say, okay, and we kind of go through a little process right then of evaluating what they're telling me. Usually they don't have a whole lot of proof right then at that time for me. The bar is somewhat low on that. What I'm going to do right then is order the inspectors to go out and take a look at the house. They have 14 days to do that. I warn the tenants to cooperate with these people so that the inspectors can get in, and then I reset both cases back in at the same time if there's a failure to pay rent, typically 15 or 16 days later, long enough to get that report back to us. And then I tell the tenant, come prepared. You have the right to have an attorney. There's self-help. There's a whole liturgy that goes on. And then they come back in, and then we have the hearing about what happens. Typically, in most of the cases, the landlords are trying to make the remedial repairs. There's very few that come in and say, I'm not doing it. I disagree. How long that takes is really the subject of what's going on. And you're trying to keep the pressure on the landlord so that they accomplish the repairs. Like Judge Green said, it's a remedial action. You want the repairs to be made. That's the whole objective for it. And then at some point later on, you decide what you're going to do with the money, whether you believe the landlord acted reasonably in doing that, depending on how long it took and what the conditions were that needed to be repaired. And then you kind of have a whole host of things you can do with how you want it. You can give the money back to the landlord, you can discount rent, you can waive rent, and that's kind of the whole system. And that's what I see typically in a case.
I guess, and again, I know that we didn't ask the proponents to get into the details, but I just remember one of the cases was people were without heat for 27 days in the winter. I guess I'm wondering if somebody finally got into court and told you, Judge, I've been without heat for 27 days, and the landlord isn't disputing that. Is the process you just described still have to happen? You're going to have to send somebody out. It's going to take 14 days to determine a bunch of things and so on and so forth. Is that what happens?
Each case is a little different.
Okay.
If the landlord agreed that there was a violation of the warrant of habitability or one of the 5 conditions that is a rent
Okay.
escrow, I'd establish the rent escrow right then, and I'd order the landlord to make the repairs, and I'd give them a time frame as to how long I thought appropriate. This is after hearing from both sides. Remember,
Right.
there's a lot of people forget that there's 2 sides on everyone, and everyone's giving me
Sure.
information. I'm trying to make the best decision based on that information. I'm trying to be fair. Ultimately, that's our goal.
Well, thank you. I'll go back now during the hearing and ask the proponents to give me a little more information about those cases and see how that really played out. Okay, thank you, Judge.
Thank you. I think you have to wait for. Okay. Just agree.
No, and I want to thank you again also, Senator, but I also want to say, and sort of the chief's experience and my experience somewhat the same, Prince George's County and Baltimore City. And we're very fortunate in that we do have code enforcement and we have housing that conducts these inspections. And so we may be on a given case, getting a case where the tenant had been so frustrated that they contacted 311 and they've already had an inspector come out to the premises. And so we may have that information in the failure to pay rent case, so we can determine the setting up of the escrow, the consolidation matter, and then potentially re-engage the inspector to go out. But I would love to say, but it's it's not true, Senator, that every jurisdiction has that. So in some jurisdictions, our judges, Baltimore County, have become experts because they're having to take the testimony. And it's, again, as was raised by both the proponents and some of the opponents, other than the judges. But the idea was that we have to take testimony to establish perhaps notification. We have to take testimony as to what the repairs were that were made by potentially the maintenance folks or something like that, potentially different from what the tenant is representing. Whereas in my jurisdiction, I'm very fortunate because we have licensed inspectors, experts that go out and review, take pictures. I have a much better ability after this time period to assess exactly some of those things. The heat question that you asked, though, that's a 5-day inspector process that runs on a different track than, let's say, aspects of mold or some other leakage or something like that. That's very serious. Don't misunderstand me. But the heat issue that was raised is certainly something, especially in the winter time, that we need to make sure that gets done right away. And then that case may also be separate tracking through the executive branch and their legal division, despite what the court might be doing and trying to reconcile what's going on here. So there are a variety of things. That's all I wanted to say, is that some jurisdictions have inspectors, some jurisdictions we have become trained by way of experience, but we're hearing from both sides, and that may take a little longer in those jurisdictions. So.
Senator Washington.
My question is going to be for one of the judges, so whoever wants to answer the question, but
First step, Senator.
Senator James asked some really good questions, and some of them were my questions. Just off the top, you mentioned the licensed inspectors. These are licensed inspectors from your jurisdictions or folks that you've hired?
From the county.
They're from the county.
Or in the city, I believe it's from the city.
Got it. Okay. Cool.
Yeah.
Okay.
It's a
And
good relationship that we have with the county on that. So
got it. And because I'm getting a reputation from the chairman here that I think about data a lot around here and what it looks like. And I wonder, you talked about hundreds of cases, thousands of cases of inhabitability or these pieces. Can you give us the actual numbers on an annual basis of how many of these cases come before you in your jurisdiction?
I have that data at my office. I don't have it right on my fingertips. But I believe it would be on the order of a little over 1,000 a year, I believe.
1,000
statewide.
Statewide,
1,000
a year.
Yeah, I could be off by a couple hundred one way or the other on that. All right. But I have that data. It's posted. We have it posted on our websites. So I'd be happy to share that.
Do you, in your data that you have back at your office, do you remember if there was repeat cases or from the same landlord or from the same property that you see where there's repetition from this landlord, where people are coming in for escrows and inhabitability? Do you see a theme in that from some of the landlords?
There's not data to that effect.
It's not data to that effect. Is that what you said?
Well, it would, when you sit in a particular jurisdiction, you will see the same apartment complex come up time over time. And you generally would know as a judge who the better landlords are and the not so good landlords.
And what do you do in the cases when there aren't so good landlords? When there's a case like this, we're talking about inhabitability. They come before you. There's multiple people in that jurisdiction that come before you. They obviously have to have their own individual escrow accounts. What do you have to help remedy the situation of those that property owner of that property has multiple people coming into you to ask for relief?
I can order them to fix the repairs, and if they don't do it in a timely manner, then I can abate rent.
Right, abate rent, right. But what about the property at a whole? I mean, if we're seeing multiple ones at one property, do you order them to review the entire property? Do you have jurisdiction to do that, to fix to review their entire property and make sure there's upgrades or renovations or anything if we see repeat offenders in this case?
That would be under the province of the county inspectors. Then they would have the authority to do things like that. We have to base our remedies on what evidence has been presented in front of us.
Got it. And in that data, can you share that data with us? Can we?
Yeah,
can
it's
we
on
see
our,
that
it's
data?
posted on our website. I
Where,
mean,
where the
it's-
numbers are, the properties, how many times
I
there were
don't have the,
escrows?
I don't have that kind of data. I have the numbers of rent escrows that were filed by county, by month.
Got it. I think our concern is simply that there's obviously repeat offenders.
I think the
That-
county inspectors would know that.
Yeah, and I know that too. I feel like unfortunately we're missing the mark on like what these families are going through every single day and the process and how long it takes from them notifying the landlord of the issue, them going through it, then not hearing anything from them, then having to go to the county to help, to ask for help, and then they not doing anything and going through 6 more months of waiting and waiting and waiting. Then after that, coming to the courts finally, because I just realized that I can do an escrow account after 8 months of living in this property that is inhabitable. And then I have to come to you and wait 3 or 4 more months to get remedies. And it just seems like we're not helping these families out that are going through this. And I wonder, in collecting data and also finding new ways and innovative ways to help folks, because I know you guys don't like this bill at all. And I'm hearing from many people that this isn't a solution. And I think Senator James said it right. What is the solution? What can we do to help these people that we're seeing blocks of people have the same issue and the same property, and there's no remedy for them?
Well, there's a consolidation process in court. They could each file those and do that and keep it in the district court, or they could file a class action in the circuit court. One of the things that we've been focusing on is our help centers. And, we've been advertising it. We've been putting on social media that any individual can call our help centers and receive legal advice from attorneys that we pay for from legal aid on any civil matter that they want. And we provided over 140,000 instances of service last year. But
I just think if they're coming to you, it's their last resort. They can't figure out anything else. They went through all the resources, they went to everybody else, and they're coming to you for help. And it just seems like if I'm a tenant, I feel like I have no help because this landlord is the worst of the worst. We're talking about the worst cases, and there's no remedy for them. Thank you.
No, thank you very much, Senator Washington. Thank you, Chief. I know that you're not in a position to make policy prescriptions, but you're just, we do thank you for the information that the court makes available to tenants around the state. So thank you for your time today.
Thank you,
Thank
Chairman.
you, Judge.
It's always a pleasure to be in front of the committee.
Excellent. Like always a pleasure to have you. Additional questions from the committee? Excellent. So with that, that'll end the hearing for House Bill 691 and Delegate Pippy. The time has finally come. Welcome to the committee, House Bill 126. You're up.
All right. Happy to be here. So Delegate Pippy, for the record, testifying on HB 126. So Chairman Smith, Vice Chair Wallstreicher. Most of you have seen this bill before. Matter of fact, we did a collection. I think 8 of the 11 members here actually voted for this bill. It was the crossfile of Senator Lee before she was appointed to the Secretary of State. So what the bill does is the following. When we passed child pornography at overhaul in 2019, there was a small area of oversight. And that pertained to if an individual with a camera takes photos, puts it in a dressing room, puts it in a private residence, puts it in a hunting cabin of a child, of a minor, that could be in a naked photo, essentially. And the penalties for that were so minor. It was a small misdemeanor up to a year, 2,500. So what this bill does, it clarifies a few things and it increases the penalty to 5 years. Still a misdemeanor, still $2,500 fine, but it clarifies that this can occur also in a private residence. And it also adds some guardrails about the 4-year age gap. So the minor and the potential defendant have to be 4 years apart. So that's helpful in clarifying. But again, it's a good bill. It was voted unanimously out of the House. This year it was voted unanimously last year, unanimous out of Judiciary, unanimous out of JPR last year. And here we are in the Senate, and I would appreciate a favorable report. I think this closes a loophole to protect our most vulnerable assets in the state, which are our children. So appreciate a favorable consideration. It has the support of MCASA, Montgomery County State's Attorney's Office, Prince George's State's Attorney's Office, et cetera. And then the last thing I'm going to say is just there was a very public case where we had a judge, a circuit court judge in Caroline County in Maryland, that had placed a camera in the bathroom at his hunting lodge and actually invited young children and to come hunt and spend time with him on the weekend. And what he was doing is he was filming and taking pictures of them in the bathroom with their clothes off. And that judge was about to be arrested and he killed himself as the FBI approached. That happened right here in Maryland 2 years ago. So a bill like this can kind of close the loophole in a lot of those situations. So again, I appreciate your consideration.
I'm curious. I remember having a bill that may have been similar to this, may not have been this bill when Senator Watson was on this committee. And I say that in the preface my question. If a parent were to put a camera in their home and it happened to capture their child, could they be convicted under this particular?
So one of the languages that we use is what's called prurient intent. I'm sure you've probably heard that before. And the reason for that is to separate a scenario like with me. So I have 2 boys, a 6-year-old and a 4-year-old who get baths, at least when their mom's around. And, if a cute photo was taken of them, not a horrible photo, but a cute photo, that is not with prurient intent. And that language it's federal language. We've used it in other bills here in Maryland that distinguishes between a scenario that you described, sir, and a scenario in which, let's say, somebody was taking a picture to then post on, pornographic sites. And I also want to point out that, and I may have already said this, but this bill is in the exact same posture as it was last year when my good friend from Baltimore County voted for it, Senator Signor. So. No, he knows that's not a burn.
It's no burn. I'm just wondering if it's the same bill.
It is the verbatim exact same bill it was last year when the tougher JPR, was here and they all voted for it. But no, that's a good question.
And what happened to it if it's?
So this bill, I'll just put it out there. It passed the committee, passed second reader, was on third reader. It was the last calendar. And then a couple of your colleagues were doing these big speeches at sine die. And my bill died at like 11:59 in the Senate. So I still love you guys.
It's the Republicans.
I'm just
though.
saying.
The Republicans were giving the speeches.
I'm just saying. So I hope you guys help me out this year. So I still love you guys. And we can maybe get it through a little sooner. Thank you.
Hi, Bill withers on the vine.
It does. Yes, it does.
All right. No, you don't. No, you don't. All right. Less is more, man. Less is more. All right. Additional questions from the committee? All right. Thank you very much.
Thank
We'll
you.
get to
Thanks,
work.
guys.
All right. Thanks. All right. So with that, that'll end the hearings for the day. We do have a voting session ahead of us. So let us 5 minutes. No. Like maybe like half an hour, maybe half an hour. I know, half an hour. Who has hearings in the House still? You do, 2, 3 people. And Jill does as well. Let's do a half an hour. We'll come back in at 5:15. Let's go 5:20. We'll come back at 5:20.